What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great night so far. Man, I've got a good show for you tonight. We are jumping around to a bunch of different courts. I got to cut up into the segments. The first segment is don't do drugs, guys. I've got a guy that gets evicted out of a house that he doesn't live in. It's sad, but it's funny at the same time. The whole court's confused. Like, just wait till you see it. Then I got a bunch of Judge Simpson from yesterday. Generally Thursday nights I do mostly Judge Simpson dockets, but that one clip of his took, I don't know, 20, 25 minutes, and I wanted to play other stuff too. So I added a bunch of Judge Simpson stuff from yesterday. And then we got a Court Genius. Yeah, we got a lot of stuff going on tonight. So I hope you guys enjoy it. Also, before I do start, giant shout out to Miss Deborah Davis, who was sworn in as the prosecutor today. If you guys haven't seen the video, she had it on her channel. I put a link into my Discord. So if you want to see it, the link's there. I'm sure one of my mods will drop it in the chat so you guys can save it for after my stream to watch. Well, it's only 5 minutes, so if you want to go watch it. I am not going to be sharing it tonight. I want to make sure that she gets all the clicks and views on it. So I did not want to share that. But I do want to let you know it's there. So go check her channel. It's she has a fun channel. She doesn't cover a lot of court though. She mostly covers her farm life, which is a fun side of her to watch if you've never seen it. All right, I am rambling. Let's get going. I don't think I have anything else to say. So before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
All right, the city of Detroit versus Rico Guess. Case number SP 1599423, counts 1 and counts 2. Appearance for the record, please, Ms. Harris.
Oh, real quick about this one. This guy flashes his ID a couple times. It's been blurry for me. I think it's blurry. I don't think you can read it, so I didn't edit it out. If you guys can see it and read it, let me know, because I'm gonna have to stop. I'm gonna have to put my little icon over it for the rest of the hearing. And you don't want me to do that, because this guy's a trip. He's fun. He's fun.
Sheriff Harris, on behalf of defendant Rico Guess, please state your name for the record.
Computer. Doobie.
Rico Guess.
Yes, sir. Hurry up. They calling me.
You're unmuted. Go ahead and state your name. You're unmuted.
I hope he doesn't have one of those roll up whatchamacallits in his hand.
No, you had it. I'm still trying to learn how to work the computer. It's my brother.
The computer now. There's something looked like it was rolled up in his hand. State your name. Good morning to you, Mr. Guest. State your name, please?
Rico Guest.
All right. Good morning to you, Officer Tuttle. Good morning to you. Can you put your appearance on the record, please? Officer Tuttle.
Morning.
Good morning. Can you put your appearance on the record, please?
Yes, sir.
Heather.
Name, badge number, and department.
Officer Macy Tuttle, badge number 3606, Detroit Police Department, 12th Precinct.
All right. Good morning to you. Day is date and time set for a trial. Ms. Harris, go in the breakout room with Mr. Guest and work this out for him. Keep in mind, he has an absolute right to die. Today is the date and time set for trial. Mr. Guest, you'll see the prompt up there. Join the breakout room. Hit that prompt, all right?
Let me say, Doobie, come look right quick. You probably got to help me out with the computer.
He still got it in his hand, too.
Oh, this is the license.
No, the other hand.
Oh.
You dropped it. You have a valid license, sir?
Yep, yes, sir, I got the license.
Driver's license, please.
It's
I'll let you know whether it's valid, Ms. Harris. Go ahead and breakout room with them.
okay. Doobie, how do I go in the breakout room? Doobie, come in. I don't know how to.
Mr. Guest, do you see, did you?
Doobie, I thought I saw a Doobie.
Yeah, my little brother. The breakout room. How you doing, dudes? Don't take me off the screen. I don't know how to.
All right. So let's pass the matter. Let's go back on. All right, let's go back on the record with Mr. Guest. Mr. Guest, you do have a valid driver's license.
Yes, sir, Your Honor.
All right, that's blurry, right? I've watched this and rewatched this, and I'm pretty sure that's blurry. I couldn't see it. Even when I zoomed in on it, it was still blurry. So I think that's the last time he flashes it, though.
What's going to be the resolution?
I was not able to get him in the breakout room. So.
All right, let's try it again.
Doobie, you gotta do the breakout room again, because I don't know how to press none of these buttons. Work this thing. And
It's all you got to do is press the thing. It says join room.
I'm scared of computers. He said press the thing to say join rooms.
6. Join breakout room 6.
Got it.
Oh.
Hey, Doobie. Hey, Doobie. Hey, Doobie. Need your help. I'm afraid of computers. We get to see Doobie more than we get to see Snoop Dogg Jr.
Pass the map. Mr. Guest.
Dude is so... I don't want to say he's stoned, but man, he is the stereotypical stoner. He is so happy. Oh man, I hope he's not stoned, and then I want to see him when he is, because that dude is the happiest guy in court right now. Mary Smith, you are killing it on subscriptions lately. Thank you subscriptions. I used to do that. I stopped doing that. Get those two words confused. Anyways, Mary, thank you so much for the 10 gifted memberships. I appreciate it. Welcome to the 10 new members. Mary Smith, that is awesome. All right, let's get back to Doobie. Doobie!
What's going to happen, Miss Harris?
Your Honor, the court did indicate he has a valid license. I will also note for the record that based on our discussions, the car is actually not his. It is not in his name. So, Mr. Bowman, are you in agreement with the dismissal? I understand that the misdemeanor insurance matter is for the owner of the car. You're muted. And I want to mistake your silence for acquiescence.
For me? Can you hear me?
No.
You can't hear me?
Mr. Guest wants to talk now.
Your Honor.
He wants to have diarrhea.
Mr. Guest, could you hold on for just a second?
Yes.
Mr. Bowman. You want to speak to your officer about it? Miss Harris is saying that she's asking for a dismissal based on the license because he does have a valid license, and we have substantiated that. As far as no insurance, it's Mr. Guest's contention that that wasn't his car, so that ticket shouldn't have been written as a misdemeanor. And I don't know. Go ahead.
Ms. Harris has properly stated the law, so I have no objection to dismissal of the no insurance ticket.
All right. Cases are going to be dismissed. One for we'll just put dismissal, and one is providing valid documentation, and the other is just going to be a dismissal for the. Officer Tuttle, I wish you a safe and happy holiday season, and you be safe out there.
Thank you, sir.
And Mr. Guest, I wish you the same. All right.
Thank you, sir. Your Honor.
All right. If there's nothing further, I will say happy holiday season. Best of luck to you.
It's my birthday yesterday.
Oh, it's yesterday. You had shared a birthday with Mr. Cheater. Sagittarius, huh? It's a Sagittarius today. Happy belated birthday, sir.
Thank you, John.
All right. Best of luck to you.
All right, thank you very much. Yeah, you can come cut the computer off. I don't know how to work it.
I'll put you out before
Okay.
he raises that doobie again. Mr. Jeter, you.
That was just too much fun. Too much fun. Great way to start off the night. Heather, thank you so much for the super chat. Spoiling yourself. I do appreciate it. Thank you, Heather. Otto, the spoil Heather fun. Thank you, Otto. I appreciate it. Heather appreciates it a little bit more than I do, but we both appreciate it. Thank you, Otto. All right. I can't stop laughing. That guy. I don't know why he cracks me up so much. Sparkle Boots. Call me crazy, Heather DeGoo. But you seem excited about your visit. I hope she's excited about her visit. She should be. She should be. Thank you, Sparkle Boots. I appreciate it. All right. All right. The next video is the guy that gets evicted out of a house he doesn't live in. This might be so this is don't do drugs, guys. And again, I'm not gonna say he's on drugs, but yeah, the signs are there. Let's just say the signs are there. Let's go.
In iPad booth 1, I think you might have said your name was Thomas. I'm gonna have you unmute.
Nope, I haven't smoked since I was 25. So it's been 15 years since the last time I did it. Actually, that's not true. I did it one time. I think I was like 30, 31, and I got super sick. My fun time with that has passed. I got the spins real bad, so can't do it anymore. I let myself go on that, which is fine. I don't need it.
Okay. Yes, I worked for Mr. Goodyear for 2 or 3 years, and he owes me lots of money. And
hold on, sir. First, give me your name and how to spell your name.
Thomas Needham. And I tried to come and file my papers correctly. I went to the Northwest Project, but this lady that works for him, she sent somebody in my house to clean up, and they tried to evict me. We had a fire there. There was a fire.
Okay, hold on, sir. Just hold on. Ms. Casimir, I'm going to hear from you. And do you know this individual's last name? I couldn't catch it.
I believe it's Thomas Needham. I don't know how to spell it. What I can represent to the court is that I believe he called our office earlier this week. He stated that he resided at an address that is not the address in this case. And we could not confirm who he was. Our office at least couldn't. So I'm not sure if he's on this case because the documents were provided to a different address than the one he provided to our office. So I don't know.
Okay. Hold on. Thomas, I'm going to use your first name here. What is the address you live at?
I live at 1435 Beach Street. I think it's 1735 Beach Street.
You said, so you live at 1035 Beach Street?
1735.
Sorry, you're going to say those numbers one at a time.
35. 1735 Beach Street.
Okay, you've given me 3 different numbers, none of which match the address for the current summons and complaint.
Just keep guessing. You're eventually gonna get it, man. Just keep guessing. There's so many more 4-digit possibilities. You just keep going, man. Just keep going. They're not telling you to stop yet.
Well, it's 1435 Beach Street. I'm sorry, I've got a bad cold and I'm not feeling well at all.
Okay, so 1435.
Yes, ma'am.
Okay, so Ms. Casimir, go ahead with any you have.
Well, Your Honor, we would ask that the writ be entered. That's not the address of the property that's at issue in this case. So we would ask that the writ be entered. I can tell the court that 1435 Beach Street is the address that he provided to our office. But the address in this action is different than that, obviously. So we would ask that the writ be entered today.
So at this point, Ms. Lucas, is this an individual that you represent, or do you know?
Oh, to the best of my knowledge, we do not represent this person, but I also was unclear about the last name, so I'm unable to search our system. Can we ask if you would try to spell it?
Needham. Needham.
Needham.
Yeah.
Okay, we'll give Ms. Lucas just a minute here. You have an order on this one.
Okay. Cool. I don't have any information to provide to the court.
Thank you. I appreciate that. Okay. So I will approve the writ. Out of the 3 potential addresses given, none match the address involved in this action. Ms. Casimir, it doesn't look like we have an order for writ on this case. If you want to send one over, I can get it signed.
Do you want me to email that or send it over with our courier?
You can send it over by email to me and I'll get it printed and signed today. I think I'm here until about 2-ish.
Okay, we'll get that over. Thank you, Your Honor.
Okay, thank you. Any matters I have missed on docket today? Anyone else here for a case? Check with.
All right. So I don't even know, how do you even proceed? Why is that guy even in court? Part of me thinks he lives at the house. He just doesn't know the address. He just completely forgot the address. That's one possibility. Second possibility, he stole someone's mail and found that, and he doesn't live there, and he thinks he's getting evicted out of his house, which is even more hilarious. Can you imagine? He just went home. He's like, "We're getting evicted, guys," and then they all move out, and it was like their next door neighbor. So many things, so many possibilities. I don't know. Moral of the story is, guys, don't do drugs. Drugs are bad. Okay. Carla, thank you so much. Late fee for whatever you want. Thank you. I appreciate it. Carla. Thank you for hanging out with us tonight. And thank you for the super chats. Okay. We're moving on. I think this is where we jump into Judge Simpson for a little bit. Let's go.
Court does call the case of the people versus Michael Clopton.
All right. He is training a judge right now, and she looks extremely familiar. Does anybody remember what her name is? It's been bothering me since yesterday when I saw her sitting next to him. I can't place her. I've seen her in court, and I can't place her. Judge Garwood was training a judge over the weekend, and it was the same thing. I've seen that guy's face before. I just couldn't place him, and yeah. I don't know if it's a prosecutor, maybe she was a magistrate and now she's being bumped up to judge. I'm guessing she won an election and that's why she's here. I don't know. But if anybody knows who it is, please let me know because it's bothering me.
Morning again, Your Honor. Michael Vincent on behalf of Michael Clopton.
Good night, Heather.
Your name, sir?
Michael Clopton.
You're on both cases, Mr. Ray?
Yes, Your Honor.
And I know that's not your writing. You only filled out one green sheet.
Well, I'm going to ask for a prelim exam.
Oh, you're asking for a prelim on one.
On one of the 2 charges.
So the 1529, you're asking for a prelim? Is that right? Unless I had the wrong. No, you're asking for a prelim on 652.
Yes.
So let's start with that one. Is discovery complete on that?
No, Judge Slay swore him in. It wasn't Judge Slay. And no legal fiction. It's not Judge Anita Man. Nice try, though. Nice try. Good joke. Hey, Terry, what's up?
Yes. As far as I know, it is.
All right. People have their witnesses available the second. All right. Preliminary examination will be set in person January 2nd, 2025. Emily, 9 a.m. before Judge Barr. Bond on that matter will continue.
May I address bond if it's at the appropriate time?
Sure. You're going to want to address it on both.
Yes.
So let's do the other ones, and then we'll have you address bond. On the other case, you're asking for an adjournment.
Yes.
What date did we give him the last time? You see, I can adjourn it to the 2nd at a different time, but you're PCC on that one.
We're missing the search warrant on the second one. The one that I'm asking to be adjourned. So as soon as we get the search warrant, we'll be ready to go.
All right, so why don't I do this? Since you're coming on the 2nd anyway.
Yeah, that's possible. It's possible, but I would think that Miss Ann would be training her if it was just going to be someone in his staff, not someone that's sitting right next to him. There were times in the docket where he gave her paperwork to finish filling out. So my guess is it's an attorney, a prosecutor or defense attorney that we've seen in court before, because I recognize her, and maybe she's gonna be a magistrate. Someone said that she's not going to be a new district judge, but maybe she's training, she's about to be a magistrate. I don't know. These are just guesses of mine.
For an exam on that one, I'll adjourn the probable cause on this one to the 2nd because we're happen to be having them that day. 2025 at 9 a.m. Bond will continue in that matter. Well, you want to go ahead.
Yes, right now there's no bond for reasons I'm not quite sure on. He has a bond. He had a bond of 5,000, 10%. He was in here earlier, and basically he got afraid that they were going to ask for a $250,000 bond and left. But he has since turned himself in.
Oh, yeah, I did that.
I'm not surprised.
Yeah, you shouldn't be.
No, I'm not.
So he was here, did not appear for his.
Just wait till you hear her case. I've got her up. I don't know if it's the next one, but I have her in this video. All right, I'm pausing way too much. We're going to let this, at least Mr. Vincent, finish up.
Proceeding and left.
Yeah, he left. Or
Yep.
Say Ypsilanti, he left out.
And I revoked his bond.
Yes.
Back.
But I'm asking for the
So
bond.
now we have him here.
He's here. His employer's here. Jonathan Hunt, he works full time for Mr. Hunt. Mr. Hunt, could you stand up so the judge can see who you are? I'm not making this up.
Hello. I believe that you're not making it up, Mr.
So I'm asking for a
He
relatively.
shouldn't have left. I mean, I'll let you
agree.
go on, but he shouldn't have left. I mean,
I totally.
there is nothing really that I can think of that's going to indicate that he's a flight risk more than that.
Well,
But I'll let you go. Go ahead. What?
I've been retained. He's listening to me. He can be tethered to his job, tethered to his home, and that's it.
Response from the people.
Thank you. I am stuck on I am stuck on the he turned himself in part. I don't understand that because he was arrested in Canton, Michigan.
I thought he turned.
Oh.
Fit.
So not only did he leave here, he didn't then change his mind, come back, turn himself in. He got arrested. What was he doing when he got arrested?
He's innocent until proven guilty, Your Honor.
He is.
So when we were here in May, I told the public defender that I would be requesting a $250,000 cash surety bond.
That's right.
The public defender went out to the hall to speak with Mr. Clopton to advise him of the same and essentially to prepare for their defense of that argument. Mr. Clopton ran. At the time that the case that he is in custody for with bond denied, at the time that he was arrested on that file initially back in July 2023, while he was being searched by the police and when the police found cocaine in his possession, he told the police, I have a warrant for my arrest.
That's what I meant by.
He knew that he had a warrant for his arrest and again, did nothing to resolve it. When they asked him, what do you have a warrant for? He said, just drugs. He has a criminal history that includes, sorry, I don't have it already pulled up in front of me, multiple drug charges convictions. He also is the subject of, and I feel that I can disclose this because the search warrants have already been executed. He is the subject of an ongoing statewide trafficking investigation. I am meeting with the law enforcement agencies next week to determine where that case is going. But his criminal history in terms of drug trafficking begins in 2006, where he was convicted of delivery of manufactured controlled substance. He was sentenced to a jail. Again, in 2006, he was charged with delivery manufacturing. In 2007, he was convicted of home invasion in the 2nd degree. In 2011, he was convicted of fleeing in the 3rd degree. I could continue on, including 2020. He has convictions for firearms, including CCW, possession by a felon, RMO, and that is his most recent conviction, at least as far as I can see from his lien. And because he was out on a drug case with the bench warrant, knew of his bench warrant did not meet, and the ongoing investigation against him and his associates, I had planned to come in here and make an argument for $250,000 cash surety. Today, he should not get the benefit of that argument. His bond should remain denied. Your Honor.
Anything else, Mr. Benson?
Waiting to hear on the statewide investigation, but he's not charged with that.
Oh, I understand that, but I also understand that he was here, left, did not voluntarily come back or change his mind. We now have him. He's a suspect in other things. And he didn't turn himself in.
What?
He's a flight risk.
I mean,
Clearly.
they told the cops that, look, I got a warrant.
And did nothing. Motion for bond reduction denied. Bond will continue. It's set. Thank you.
Yeah, Vincent tried. He tried. Whoever, I don't remember who it was, but somebody asked me if I saw Deborah Davis's swearing in. I did. And I posted the video on my Discord. I said that in the intro, but you came in late. So I just want to say that it's there. If you guys want to go watch the video, it's on Debbie's channel. I highly recommend you go check it out. It was a great moment for her. Okay, Judge Simpson. More Judge Simpson. I don't know when Eyelash Lady is. She might be now.
Courthouse case people versus Robin Fenny.
Nope, she's not now. I do have her case, though. Don't worry.
This is Public Defender Jay Bellinger on behalf of Ms. Fenny, who approaches.
Your name?
Robin Lee Fenny.
Thank you.
Thank you.
Your Honor, we are asking for an adjournment on this matter so that we can complete a mitigation for Ms. Fenny. I'm also asking to address bond.
All right. How long is the mitigation?
I'm just going to be asking for 3 weeks on that, Your Honor.
3 weeks. Okay. So probable cause conference January 9th, 2025, 9 a.m. Esteban.
Esteban, Your Honor, it's my understanding that Ms. Fenny was before Judge Perry yesterday. I don't know whether the bond was amended over there. I think it may be lower than it was. However, she's sitting currently on $200 and $100 apiece on both cases. My understanding.
On the cases out of 15.
Two. I'm sorry. Did you ask how many cases out of the 15?
No, the bonds that you were giving me were the cases in 15.
Yes, they were.
Okay, go ahead.
Correct. She's currently sitting on a bench warrant on this case for $25,000. It's my understanding that she missed a court date. She wasn't aware of a warrant. However, she was picked up on the charges in the interim.
Correct, but she also has another issue.
She does have a hold out of Van Buren Township that I'm aware of, Your Honor.
Okay, that's not the one I'm talking about, but thank you for sharing.
Well, yes, but we are not expecting her to be picked up on that writ, however.
Okay.
In terms of the other issue, I suppose I might not be aware of that, Your Honor.
And that is that when she was previously released,
yes,
she not only did she not appear for court proceeding, she also didn't report to community corrections as ordered.
I am asking for a Christmas miracle, Your Honor. I'm asking for a PR bond in this case. I have a good number for Miss Fenny. She advises she can reports community correction. She had.
That's where I say bond, but no, go ahead. I'll let it finish.
Your Honor, while she was told about community correction, she advises that she didn't remember or she just didn't know to report
So
over there.
Here's my problem. She didn't go to community correction. She didn't appear for a court proceeding. Then she doesn't voluntarily turn herself in. She's picked up, and that's the only reason she's before the court.
Your Honor, she did.
And she has all of these other pending matters, but you can go ahead.
Your Honor, she has 2 other pending matters out of the 15th. I talked to the prosecutor. There were other potentially pending matters. However, those were denied. I'm not expecting any more cases out of her. With regard to community corrections, she is obviously willing to go over there. She gave me a good number that I can contact her on. She's willing to do a tether, whatever the court would impose and find appropriate. I did ask for a Christmas miracle today, so.
Yes.
That she's been up to are she bench warranted here on October 10th. On October 20th, she picked up a new assault and battery case. That's one of the cases on the $100 bond for.
So she committed or allegedly committed an offense while she was on bench warrant status in this case.
And then again, after that, on December 6th, and I will use the word allegedly at this point because that case has not been charged yet. It's in further status for the body camera. She assaulted a police officer. So that is a warrant under review. So that one may still be coming for an RNO.
Your Honor, I would advise that I really do appreciate, I picked up the words that Ms. Hughes was putting down and the word allegedly stuck out to me the most. And I really do appreciate that one. In all of that, I would.
It means Bellinger's ignoring all of the other words. I'm going to hang on to the ones that are good. Bond will continue. I'm going to deny your request.
Thank
she
you.
hasn't done anything she's supposed to do and is out there allegedly committing other offenses.
Alleged.
Yes. But, thank you.
Thank you. All right, we'll see you in the next.
You tried.
Tried. Yes, he did.
I don't know if that was an insult to me or.
I don't think she was saying you tried allegedly.
She's still talking.
I can't. Can I go home?
I think you need to stay, see if you can get a Christmas miracle. That wasn't it. Court calls the case People versus Desiree. Is it Bonovich?
Yep, Bonovich.
All right. It was kind of tough to hear, but you did hear her say you tried, and Judge Simpson was like, yeah, he did. And then she kind of like under her breath said allegedly. Yesterday's docket was too good. His Thursday dockets are awesome. All right. I think we might have Eyelash Lady now.
Your Honor, what's the next date? What was
Hey,
the next
Mandy.
date, Your Honor?
Really? Did I give him?
No.
I didn't? I didn't want him back. January 2nd, 9 a.m.
Thank you, Your Honor.
I wrote it. Miss Cannon went off into it. Oh, and Alan turned down the heat and it's cold up here. Both of us, you get too hot, we don't care.
Aw.
It's important that we're comfortable. People don't get this. Don't get how this works. Like we should have fluid. It's okay, man. We have days like that. Court calls the case People versus Latasha Brock.
Good morning, Your Honor.
Good morning.
Good morning.
Stephanie Cannon on behalf of Ms. Brock. Ms. Brock, could you please state your name for the record?
Latasha Brock.
Latasha.
Latasha.
Yes, it is. Latasha. I got it. I looked
Thank
at
you.
it wrong. I'm sorry.
They always do.
Okay, what are we doing?
Your Honor, my client would like to have a preliminary exam in this matter.
All discovery is complete?
Do you want to entertain a misdemeanor offer?
I want to entertain that, yes.
Okay.
Your Honor, may I have just 1 second if the court we just.
I had sent an email. You want to do a revision of the PCC, I suspect I could probably offer.
Your Honor, there may be an offer extended, and I understand that he reached out to the victims regarding this or complaining witnesses in this matter. Would you be okay with the adjournment of this proceeding, Ms. Brock, or do you still want to exercise your right to a preliminary exam?
What was the first one you said?
We can adjourn this. I know when we discussed it yesterday, you asked for a preliminary exam, but there may be a possible resolution to this shy of that. And I'm just asking if you would like to adjourn it for that purpose, or do you want to go ahead and have your exam?
What would be best for me to do? What would be the right?
Okay.
Your Honor, we're gonna adjourn this.
I'm not gonna have that. You're not gonna have that discussion in open court, okay?
Okay.
I agree.
Brock. So what I'm going to do is I'm going to adjourn this out a couple weeks, let you talk with your attorney and see which way you want to go. Okay?
Yes, sir.
Fair enough?
That's fair. Sounds good.
Okay, well, thank you. I try.
And what would be the, I'm sorry, what would be the date? And would this be in person or would it be on Zoom? Because I'm on a home invasion GPS 7 right now.
Oh.
Yeah, Ms. Brock, if you could just let me ask the questions, please.
A little bit. Okay.
Your Honor, just.
That kind of makes us look different.
Doesn't it?
Miss Cannon, you are having a great day.
Thank you, Your Honor.
The defendant eyelash lady has no idea what she just did. Yeah, don't say anything. Don't.
January 2nd, 2025, 9 a.m.
Thank you so much, Your Honor.
You're welcome. January 2nd.
Would it be on Zoom?
Well, we might have to do it that way because I don't know that you can be going places.
Right.
I will make the request.
All right. No, it's okay. So here's what you do. Talk with your attorney.
Okay.
Because you're kind of locked down right now.
Yeah, I'm on lockdown for sure.
I know. So nobody knew that until you said it.
Yes, I'm confined to my house.
Yeah, confined to the house. So you know what? I'll shortcut it. We'll let her appear via Zoom.
Thank you.
And
thank you, Your Honor.
All right, because we don't need the form. She gave us everything we need in the form.
Thank you, Your Honor. I appreciate
You're
it.
welcome.
Don't answer, sir, please. Every time you open your pie hole, you get it worse trouble. So stay the course, will you?
Thank you. You
In
too.
your house. All right.
Thank you.
Clerk calls the case.
No, I think she's having so much fun. This is like Christmas for the day. I love it.
Exactly. Clerk calls the case. People versus.
Oh man, she didn't understand that what she just did didn't help her, and she still thought it was hilarious. You know what? But the guest was right. At least she was having fun. She had fun with it.
Really? Court does go.
Yeah, we're staying in Simpson for a little bit. I just
The case of the people versus Jonathan DeHaze.
DeHaze or Hayes?
DeHaze.
Thank you. That's a lot of good people.
Good morning. All right, this is a good one. This has been spread around a little bit, but I wanted to add it. It's a good one. I think this is the last clip we have in Simpson too.
Your Honor, James Sullivan via Zoom for Jonathan DeHaze.
Yeah. DeHaze. Like the Bears. Yeah.
Hard of hearing, Judge.
No, it's okay. No, I got you. Your name, sir? Jonathan DeHaze. All right. Go ahead. What are we doing?
Your Honor, there was a matter of a bond violation that was issued apparently my client presented himself on November the 27th. We appeared before the magistrate. He was arraigned on the warrant. There were certain bond conditions that were set, one of which was to check in with community corrections and register. He was also to enroll in a drug testing program. Apparently there was some confusion about the community corrections contact portion, but he did enroll in a drug testing program. He was allowed to test in Macomb County where he lives, and but apparently did not.
Who allowed him to test in Macomb?
I'm sorry. I didn't hear you, Judge. I'm sorry.
Who allowed him to test in Macomb?
That was the magistrate indicated that at the time of the arraignment. She said he made a test in Macomb County.
Testing.
He enrolled at a place called Adapt in the city of Warren, and he did.
Do we have any results?
He submitted the one test there. I don't have any results, but I did have verification from the place that he did in fact sign up for testing there. Once it was brought to our attention that he had failed to contact community corrections, he did then call community corrections to try to enroll. They told him because the matter was in warrant status, they couldn't address it. We'd have to deal with the court. He turned himself in for immediately or shortly after finding out about this. He presented himself last week to the jail and was told that we'd have to address the issue today because today was his court date for probable cause conference. So I don't think there was any part on Mr. DeHayes' part to not comply. It was just a matter of some confusion on his part about contacting and meeting with community corrections directly. And I think he is 32 years of age. He is working, steadily working. He does have a young child he supports. As I say, he did voluntarily appear both.
Does somebody have the test result? Where he's testing? He didn't do anything. He didn't go for intake, nothing.
I went to. He didn't go to the but he did enroll in a testing program, and he did attempt to make an appointment to go to community corrections, but the matter was already in warrant status. So he did appear, as I said, voluntarily, both in November and in December, on learning of this warrant. So he's not. I don't think he's trying to deliberately avoid any responsibility, Your Honor. And if given the opportunity, I do think he would comply. He does have counsel. He is anxious to address this matter. But he asked the court to consider reinstating his bond. Thank you.
Landy, before you explode.
Thank
Yes.
you so much, Your Honor. Your Honor, the people are going to request that the court review the bond decision made by the magistrate in this case and find an abuse of discretion. The facts alleged in this case are, first of all, that this is an OWI third offense.
Can I just say, you're saying on the original one? Go ahead.
Yes, the original one, right? I understand the bond has been denied right now, but the conditions ordered by the magistrate, the people appeal, were an abuse of discretion and were not sufficient to ensure public safety. This is an alleged OWI third offense with an alcohol BAC of 0.120, cocaine and THC were also present in the defendant's system. I think if I didn't already say, there was a crash, and his priors are from 2017 and 2021. People would request that he have at least intermediate, if not strict supervision from community corrections, as well as an alcohol test in place prior to any release.
Anything else, counsel? I mean, is he in a treatment program? Or is he just testing?
It was just testing. That was all he was ordered to do at the time of the arraignment on November the 27th. And he's working. He supports a young child. He's, as I say, he turned himself in, not only on the original warrant, but he turned himself in voluntarily as soon as he found out that this was, there was a violation. He immediately turned himself in. And the communication that I received from the court was either he has to turn himself in or they'll address it at the time of the probable cause conference, which was today. He turned himself in as soon as he could, which was turned out to be last week, and he's been in jail for the last 6 days. So I don't think there's any attempt on his part to try to avoid his responsibilities here.
Right, but counsel, I'm not clear how we got a PR out of the gate. if the allegations are even near true.
Well, he is charged with an OUIL 3. That is true. That was known to the magistrate at the time. We presented information about his background, as I've done here today. And the magistrate's the one that set the bond conditions. So I'm not sure. There was nothing unusual about the case, that there was no injury involved in the case. It is still just the 5-year max. So I don't think there was anything that the magistrate was not aware of under the circumstances, certainly from the face of the file or any addition.
Yeah, Miranda. Yes, absolutely. Phil's a good dude. You can trust everything he says. No is going to make you believe that drones are about to attack you. So you might want to ignore that guy. He's a weirdo. Just kidding. Love you, buddy.
Information, as I say, we provided his background information, which I restated here today. So he is employed. He and has been for some time, and he has.
Okay, so first of all, let's back up a second. I don't have any results from any testing that he has allegedly done. Let's make that clear. You're telling me that I don't have anything. I mean, from this side, counsel, understand, this looks like he didn't go to community corrections, hasn't tested, hasn't done anything.
Well, I don't disagree with that, except that he did contact community corrections after the matter was in warrant status and attempted to get enrolled with them, and they told him they were not able to process him because the matter was in warrant status. He also voluntarily appeared. He didn't wait till today's date. He came in early to present himself to try to address the situation early, and they said because there was no bond that was issued with the order that he had to sit there, and has sat there for 6 days. So he has obviously suffered some penalty.
Where are the test results?
Your Honor, I don't have them with me. I
I'll
don't
tell you
have
what.
test results.
Before I do anything, because you're just going around in circles. You're telling me all of this stuff, but it doesn't make any sense to me because I don't have any test results. You're telling me he contacted community corrections after he's in bench warrant status. I have someone that's obviously a user. I don't have any testing whatsoever. Never reporting to community corrections. In my opinion, that poses a danger to the public because I don't know what he's doing. He's not in any treatment. He's not in anything.
Well,
I'll give him a bond.
Doesn't the file reflect that he was allowed to test in Macomb County? Because she put that on the record, the magistrate did.
But I don't have the results. Follow me here.
I understand.
He still would have to go to community corrections. He could test then in Macomb County. He has to sign a release. Those results get sent to us. I don't have any of that.
Understood. I'm simply asking, would the court allow him to be discharged, be released on a bond? He can report to community corrections before he's released from jail.
Tell you what I'll do. Because I honestly, counsel, you're not hearing me. So maybe somebody can figure it out. I'll set his bond at this point. I'll give him a bond. I think he's entitled to a bond now that he's appeared, albeit however he's appearing. I'll set his bond at $50,000 cash surety. I'll consider looking at that if somebody can provide me test results and I can set adequate conditions in regard to his supervision. But other than that, I'm not doing anything else.
Your Honor,
yes, Ms. Lundy.
Could the court consider at least a 10% provision on that bond? I mean,
what?
Would the court consider at least a 10% provision or something? Maybe.
No. You're just not following this at all.
I'm following that he went from a personal bond to now a $50,000 cash surety bond, and I don't frankly understand. He's voluntarily turned himself in twice in this matter in less than a month's time. And I know the court doesn't have any.
That's the fourth time you told me that. I get it.
But it's a substantial bond modification. And
Ms. Lundy.
Thank you, Your Honor. If the defendant is released, will that be with the crime alcohol tether be able to post the $50,000 bond? I'm so sorry, I didn't hear the court.
Yes,
Thank you.
it would be with a scram tether and intermediate supervision through community corrections. So what I'll do, in fairness to your client, counsel, because I know if those results are out there, you can get a document from him to get the results so that I can have the results, and I may consider something else regarding his bond, or I may not. But I'll give you a week to get that. I'll just adjourn this out 1 week to the 26th, and we can see what we can come up with. If I don't have any testing, I'm not changing.
Your Honor, can we schedule this matter for an exam?
Is all discovery complete?
Yes.
I didn't hear your answer.
Yes, it is. I believe it is.
Yes. People have their witnesses available in a second.
We'll try, Your Honor.
Preliminary examination in person, January 2nd, 2025 at 12 noon. That's before me.
Thank you, Your Honor.
Okay. Did you need a room to do it?
Broke on here.
Okay, there's the jury deliberation room.
Okay, I'll go there.
Right. Can you make sure she sees the jury deliberation?
Your Honor, just one more item on this.
I'm sorry?
Sorry, I just had one more question regarding the DeHaze matter.
Sure.
Is the court?
He's not here anymore. He's been taken back, but go ahead.
Okay, procedurally, did the court say it would entertain a request for a bond or review the bond again on presentment of some information regarding the testing?
I need to see that he's testing. You're telling me he was testing. I don't see it.
Thank you. I'll see what I can come up with. Thank you.
Yeah. That's an attorney that doesn't practice in front of Judge Simpson all that much. And what I'm guessing happened is the attorney was telling the defendant, "Oh, we're going to get you out of jail today. We're going to be able to smooth this out. You were allowed to test over there. It's going to be okay. You're going to get out of jail." And then Judge Simpson was like, "No, not going to happen. I don't see any test results." So then I don't know. The attorney just started speaking in circles. He didn't know what to do. All right, let's move on. I think that was it for Judge Simpson. Oh, I got a few shout outs real quick. We got Brick in the Wall. Thank you so much for the super chat, and Merry Christmas to you as well. Thank you so much, Brick in the Wall. I appreciate it. And Shane at 11 months. Thank you so much, Shane. That is awesome. Thank you. You're really close to a year. All right. Let's see. Are we out of Judge Simpson's court? I think we are. Let's see. Yep, we are. Okay. This kid is so lucky he has a laid back judge. That's all I'm going to say. Let's go.
On the Samsung cell phone, which is a living room, and I can't see anybody there. Can you identify yourself? Oh, there you are. What's your name, sir?
Shut up, yo. Stop, man. I got it.
You're fine. What's your name, sir?
I was talking to somebody else. My apologies, sir. My name is
yeah, but you're in a Zoom courtroom, so you're talking to me now.
Yeah,
we can all do this in
I wanted
person
to
if you'd like.
clarify. You're interrupting me. I would like to clarify that I wasn't
I'm
speaking
interrupting
to
you? Sir, I'm not interrupting you. All right. What are you here? What's your name?
Your Honor, that's Mr. Schooler. And my apologies, Your Honor. Mr. Schooler, please remove your hat. Remember, you're talking to Judge
Mr. Schooler. All right.
Thank you. We're here for a plea this morning, Your Honor. Mr. Schooler has has a misdemeanor offer on the table. He's interested in accepting that. He's potentially eligible for HIDE as well. Thank you.
All right. Mr. Schooler, it's my understanding you're here for probable cause conference. Mr. Sartz has indicated that you're going to be pleading today. And you know that your sentencing will be done by Judge Ward, not by myself. Do you understand that, sir?
Yes, sir.
All right. Let's rename Mr. Scooter.
Judge, when you call the case, but we should probably.
Yeah.
The waiver of that, the plea in front of you and.
Yeah.
Sentencing. Or warrant out.
All right, so we're on the record in docket 2403-584. That's People of the State of Michigan versus Jordan Schooler. Will the parties please introduce themselves for the record? Mr. Billabay.
Jeffrey Billabay on behalf of the people.
Mr. Sartz.
Good morning, Your Honor. Jacob Sartz, the fourth Assistant Public Defender, appearing on behalf of Mr. Schooler. Mr. Schooler and I are appearing by Zoom this morning. Thank you.
And sir, you are Jordan Schooler, is that correct?
Yes, sir.
All right, thank you. This is the time set for a probable cause conference. My understanding this may be a plea today. Mr. Billabay.
Yes, he's wearing a hoodie. It's the Colin scarf. Yeah, that's exactly what it is. Nice shout out there.
How are we proceeding, or would you like to defer to Mr. Sartz?
You and I'll defer to Mr. Sartz.
All right, Mr. Sartz, how are we proceeding today?
Thank you, Your Honor. Mr. Schooler was offered the opportunity to, Mr. Schooler, please. I'll give him a second to get settled. My apologies, Your Honor.
Yeah, my apologies again. I'm ready to go now. No more interruptions.
All right, Mr. Sartz, what's the plea agreement?
Thank you, Your Honor. In exchange for a pleading to an amended count 1 of receiving and concealing stolen property with a value of $200 to $1,000, the people have agreed to dismiss count 1, which is a possession of burglary tools, a felony punishable by up to 10 years in prison, and count 2, resisting obstructing a police officer without causing injury, also a felony punishable by up to 2 years in prison. Further, they would have no objection if defense counsel petitions for consideration of sentencing pursuant to the Holmes Youthful Trainee Act, Your Honor. Thank you.
Okay, so I'll reiterate that for the record, Mr. Billabay. It's a plea to the amended count or the amended count 1 of RNC $200 to $1,000 upon successful plea and sentence to count 1. The original count 1, which is the burglary possession tools, that's the amended count, so that won't exist. So it'd be an amended count 2 of R&O is to be dismissed. And at this time, there's no objection to 769-4A status. Is that a correct statement, Mr. Billabay?
That is correct, Your Honor.
All right.
Haida, Your Honor. Excuse me.
Oh, I'm sorry.
My
Haida.
apologies.
Sorry.
Thank you.
All right. And Mr. Sartz, you have no objection to, or do you have any objection to me taking the plea, and then Judge Ward would be the sentencing judge? Do you have any objection to that?
No objection, Your Honor. Thank you.
All right. So may I inquire of your client of his misdemeanor advice of rights, Mr. Sartz?
Yes, please, Your Honor. Thank you.
All right, Mr. Schooler, you understand you have the following jury trial rights in this receiving and concealing plea 200 to 1,000. And I'll walk you through those rights. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have witnesses against you appear at trial, and to question any witnesses that are brought against you. You are represented today by Attorney Jacob Sartz, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. You have the right to have the court order any witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what's been stated on the record or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading to the amended count 1 of receiving and concealing $200 to $1,000. Is it your wish today to plead guilty to the receiving and concealing $200 to $1,000 and to waive your jury trial rights? So, Mr. Schooler, did you want to waive your jury trial rights and plead guilty?
I was just about to, yes, I understand it. Yes, I would like to.
All right. I'm going to have you raise your right.
Yeah, he's over 18. He's over 18. Otherwise, he would have to have a guardian there. Probably wouldn't be allowed to be by Zoom by himself either if he was under 18.
Hand as best you can. So please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right, I'm going to bring your attention back to December 7th of 2024 at the offense location. Well, it's on Pennsylvania in the city of Lansing. Were you on Pennsylvania Avenue in the city of Lansing on December 7th, 2024?
Yes.
And at that time, did you receive or were you in possession of property that you understood was stolen at the time or that was not yours to receive?
Yes.
Why don't you tell me what happened, Mr. Jordan or Mr. Schooler?
So I was there that night. It was early in the morning. I was out, and the individuals, the officers, they had saw me running across the street from a dealership. They had saw me running, and when I had noticed them, they had asked me to stop. And when I noticed them say stop, I just ran. And then when they had arrested me, they had searched my belongings and they had found the quote unquote 2 items that are considered the burglary tools, the cat's paw and the flathead screwdriver, and the I believe the Dodge Ram hubcap.
All right, and so Mr. Sarks, this is a factual basis that could be for count 1 or count 2, because I think he was in possession of what's indicated was a pry bar screwdriver, and that he was told to stop by law enforcement, did not. Either one of those would make the factual basis for count 1 or count 2, which would be for the underlying basis of the misdemeanor plea. So Mr. Sarks, did you want to question Mr. Schooler, or did you want to take the factual basis for count 1 or count 2 instead?
Thank you, Your Honor. No, that's fine. We can just proceed with the factual basis for the original felony charge. And Mr. Schooler, to the best of your knowledge, the police suspected that you were intending to take hubcaps from the local dealership. Is that true?
Yes.
Yeah, and
right.
you were in possession of a hubcap that had been taken from a vehicle nearby, correct?
Well, I have no idea that it was taken from a vehicle nearby, but
Yeah,
it was.
no, Mr. Schooler, Mr. Schooler, if you want this plea to go through, you have to be honest with the judge. You knew darn well that hubcap was stolen, right?
No,
'Cause you
no,
took it yourself.
again, when they had it told me that the VIN that matched up and that, so yes, again, I know exactly where it came from. Yes.
All right, so you knew the hubcap was stolen then, correct?
Yes.
And you had tools in your possession that could be used to take off hubcaps, correct?
Yes, sir.
Okay, thank you, Your Honor.
All right. All right. Any questions concerning the
The attorney's so over him. It's like, dude, come on. Like, I have so much more important cases to do. You stole a hubcap. You're getting a plea deal. Just say, yes, I did it, and let's move on. Why do you have to make this so long?
factual basis, Mr. Billabay?
The people are satisfied.
All right. Mr. Sarts, any questions concerning the factual basis?
No, Your Honor. I believe that's a sufficient factual basis for count 1, which we can use for the misdemeanor plea. Thank you.
All right. I find that count 1 factual basis to be knowing, voluntarily, and accurately made for the amended count 1 of receiving, concealing $200 to $1,000, and we'll refer to probation. So, Mr. Schooler, you should within 48 hours, now by Monday, I think by Monday, you should go to the probation department. That's the 5th floor of the City Hall of Lansing. And what they'll do is they're going to create a report for Judge Ward, and Judge Ward will see what options are available to you at sentencing. Once you go and report to the 5th floor, I think probation is right to your right as you go onto the 5th floor for the City Hall of Lansing. That is 124 West Michigan Avenue in Lansing, right across from the Capitol. And we'll set sentencing for
February 27th at 8:30 on Judge Ward's docket.
All right. We'll set it for February 27th at 8:30 in front of Judge Ward. Anything else for the record in docket 2403584, Mr. Sarts?
Nothing further, Your Honor. I'll make sure I file a petition requesting HIDA status form for the sentencing.
All right.
Thank you.
All right, thank you. Mr. Schooler, do you have any questions of me concerning your referral to probation or the sentencing date of February 27th?
No, sir.
All right, you're all set. Thank you for your appearance today. Thank you, Mr. Sarts.
Thank you, Your Honor.
Legal fiction, you were cracking me up. Of course he has a race car bed. That's why he needed the hubcap. It all makes sense now. Oh, man. Talk about the crime of the century. That kid. Oh, man. Hopefully he gets his life together. I feel like that's what court's going to be in 5 years, is a bunch of kids that are cocky as shit. All right, let's move on. We're going to move on to the last case. I wanted to end the evening on something a little lighter. Now, there are definitely mental issues with this defendant, so let's keep the jokes away from that kind of thing. It's just it's charming. I want to just say it's charming. That's why I'm playing it. But yeah, let's not tear into this guy. Yeah, that's all I'm going to say. Let's go.
Good afternoon, your name?
And Russell of Fountain.
All right, so Mr. LaFountain, you have a show cause on one, and looks like
I just don't want to become a bully channel at all, and this is going to be way too easy for jokes to fly, and that's why I just want to give the warning. That's all.
should have been arraigned on this one. So we'll do the arraignment. This says on November 1st of this year on Northside Park there in the city of Otsego, you have a misdemeanor for being there outside of park hours. That is punishable by up to 90 days in jail, $300 fines and costs. You understand the charge?
Yes.
Do you wish to enter a plea of guilty or not guilty to that charge at this time?
Guilty.
And has anybody forced you or threatened you to make you plead guilty?
No.
Are you pleading guilty to this because you believe you are guilty of this?
Yes.
Were you present in the park there, Otsego, after hours?
Yes.
All right. So I do find that that is a factual basis upon which I can accept your plea and that your plea is knowing and voluntary. It would just be fines and costs at this point. What we mean by that is it's a $50 fine. With that is statutory cost of $75, crime victims' rights fee of $75, and state cost of $50. So you have a total of $250 on this one. I wrote right on there, you have 90 days to pay that. If you need more time than that, that's okay. But you have to call the court and ask to get put on a payment plan, all right? The other case is a show cause, meaning this is an old file, but you still owe something on it. Looks like reason you were here for show cause is you still have outstanding fines and costs on this in the amount of $673.44. Were you ever making payments on this case?
Have I ever?
Yes.
Sorry, what?
So you were making payments, but you haven't made a payment in a while. Are you able to make payments again?
No, I don't believe I ever made payments.
All right.
I never made payments.
Well, we need you
I
to
don't
make
know
some kind of payments on it. You understand that?
Just put me in jail. I really don't understand the life. I don't understand life. I'm a kid that fails. Just please just fail me again and again and again. Just a failure again and again and again.
All right, so listen to me. Is this the only other reason you're in jail? You would get out of jail. I would let you out of jail. But that's because you're going to tell me that, how do you support yourself? Do you work?
No. People
So
pay.
how do you
people
support
pay for my
yourself?
living. The family.
Okay. You're able to trade community service for this in lieu of some of those fines and costs, but you got to do something. Otherwise, you just stay in jail.
Good. Well, good, because I'm I'm not a good person, and I shouldn't be on the streets, and I shouldn't be. I'm no good.
Do you want to stay in jail?
No, who wants to be in jail?
Well, that's what I'm telling you is you can get out of jail. All you have to do is tell me that you're going to try to make some payments on this case where you owe money from last year. As long as you tell me you're going to try to work on that, I'll let you out of jail.
You know what? I'll try and work on that.
That's all we need to hear.
I'll give up. I've been giving up guitar. I'll give up guitar playing and put my future towards that job.
I'm going to release you from jail because I'm going to kick this out for 90 days. We'll see what you do in the next 3 months. But if you make an effort to make some payments on this case, then you won't even have to come back to court on it, all right?
In the next 3 months, all I have to do is get a job, basically.
Yes. Or do some community service, either way. I think, Ms. Strasser, this might be one for your office to put their social worker involved, maybe get in contact with Tanner. Probably needs some guidance on what to do on this, but I'm not going to keep you in jail on an old case. You just need to pay some money, okay?
Wow. I mean, I can see, I get services through the ACT team. Since if I take my time away from hobbies and smoking pot, see, I'll give up smoking pot, and I'll just, I can really do this.
Well, okay, and like I said, you don't have to have a plan right now. You have some time to work on your plan. I'm going to give you 3 months to sort of come up with a plan. But as long as you're moving in a good direction where you're trying to pay some money on this, you won't have to sit in jail on an old case, okay?
Okay.
All right. So you're going to get out of jail in a few hours, and then you're going to get a court date to come back in 3 months. All right? And that gives you a lot of time to work out a plan, all right?
Can I reside at my grandfather's house?
As long as that's okay with your grandfather, I'm not going to tell you where to live.
Okay, because my grandfather, he'll be able to help me out with rides.
All right, then you're all set.
To work and everything.
We're good to go then for today. You're all set. You should be getting out in a couple hours.
All right, thank you.
All right. I see you guys not liking me saying this is lighthearted. Yeah, no, I just felt like he was happy at the end. I really do. And he's just got to stop playing guitar and smoking pot, and he can get his life together. Good for him. Hopefully he gets his life together. I don't think this was sad. It started off sad, and now he's happy. He's getting out of jail. He's going to get some help with the social workers. I don't think that's sad. I think that's a happy ending. So, you can have your come to Jesus moment with me if you want, Sparkle Foods. But that is the end of the video. So we're going to go raid somebody, and we can actually raid someone different tonight. Lone Wolf's not going to like it. He's gotten too used to our raids every night. So we are going to raid KDZ. We're raiding KDZ tonight. I'm actually going to be on her channel on Sunday. We are going to be discussing the McDonald's lawsuit with the hot coffee. It's going to be fun. So that's going to happen on Sunday. I don't know exactly what time it is. I feel like she goes live at like 5, like somewhere like 5:30, 6 Eastern Standard Time. Not exactly sure. I need to figure that out. But I will send out the notifications. I'll make a community post about it, so we can, so you guys can all go hang out with us there. So that is happening Sunday early evening. So that'll be fun. So we're gonna go hang out with KDZ. Lone Wolf is live right now, so if you'd rather go there, I'm not gonna be upset. He would absolutely love it. And but yeah, let's go hang out with KDZ. You guys are awesome. Thank you so much for hanging out with me tonight. Thank you for the super chats, the gifted memberships, the membership milestones. And we had a couple new faces in the chat. Good to see you guys. Miranda, come hang out with us more. We're fun. All right. Just have a great night. Until next time, bye.
Mhm.